Are you going through a divorce? Are you concerned about child custody arrangements? Hi, I'm Simon Dippenaar and I'm a family lawyer. The most emotional aspect of divorce is undoubtedly child custody. Technically, we talk about care and contact now. The Children's Act updated the terminology to reflect the fact that a child is not a property a parent owns. But we still use the term child custody because it's familiar. The law makes a distinction between custody and guardianship and between legal custody and physical custody. So let me explain these terms. A guardianship is an adult's right and responsibility to manage a child's interests, manage any assets or financial aspects of the child's life, assist the child in legal or contractual situations, give consent to the child's medical treatment, marriage or adoption, give consent for the child to travel out of South Africa. Our South African courts normally grant guardianship to both parents as part of the divorce settlement. In certain circumstances, the court may grant sole guardianship to only one parent or to someone who is not the biological parent. This tends to happen if one or both parents are unable or unfit to care for the child. Now, physical custody means physical control over the child and supervision of their daily life and living arrangements. The custodial parent provides the child with food and support, day-to-day needs, education, a home. Married parents share custody. On divorce, they must decide who will provide the primary residence for the child. In other words, have custody. If the child lives with a parent, most of the time that parent has sole custody. The other parent has contact for access rights. Now, joint custody means the child's residential time is divided equally between both parents, but this can be disruptive for a young child. In practice, it is usually more manageable for them to have a primary residence and regular contact with a non-custodial parent. Legal custody is the right to make decisions about the child's upbringing. Normally, both parents have legal custody unless there is a reason not to grant this. Contact with the child refers to the non-custodial parent's right to see and spend time with their child. Divorce agreements usually grant the non-custodial parent reasonable contact time, but it is a good idea to define what is regarded as reasonable to avoid conflict later. When parents can't agree on the care arrangements for children, the courts may require a parenting plan. But a parenting plan is a good idea even if the divorce is amicable. It lays out the roles and powers of each parent and includes a schedule for time spent with each parent. It may also include details of school and religious holiday arrangements. All arrangements should be based on the best interests of the child, not the convenience of the parents. The opinion of the child may be taken into account if they are sufficiently mature. The family advocate is a state official who helps divorcing couples reach agreement on child custody, contact, and guardianship. When divorcing parents can't agree, the family advocate will review the circumstances in terms of the best interests of the child and then make a recommendation to the court. Now, what about maintenance or child support? Maintenance is not tied to custody or contact. All children have the right to receive financial maintenance, and both parents have a duty to contribute to the child's upbringing. No one can refuse to pay maintenance as a means of bargaining for contact time. Maintenance is calculated according to the Maintenance Act 99 of 1998 and the Children's Act 38 of 2005. Maintenance orders are orders of the court, and failure to pay is a criminal offense. I've been practicing family law for over 10 years. I act in the best interests of the child in all cases, but I always strive to reach an agreement both parents and the child, if old enough, are comfortable with. If you have any questions about child custody, please give me a call on the number in the signature below.